Justice Verma and his panel have given what many would say is a very far-reaching report on sexual violence and sexual crimes against women. They've called for some very dramatic changes. What is your reaction, firstly, with some of the suggestions they've made, such as tougher penalties that stop short of the death sentence?
Look, I've always been saying that already in the law, there are stringent provisions and stringent penalties, certainly in cases like rape, dacoity, murder, and so forth. There was, of course, a very strong demand immediately after the brutal and depraved incident in Delhi that such people should be awarded the death penalty. But there was a very strong opinion to the contrary as well. I take it that Justice J.S. Verma and his team have considered all points of view and have finally come up with the recommendations. I do believe that in terms of sending a message that perpetrators of such heinous crimes will be dealt with severely is not lost on the people, and that is a good message that the report has sent. I do believe that the cabinet will consider all these proposals very seriously and take a very expeditious view in the matter.
They also did not recommend lowering the juvenile age from 18 to 16, which was another key demand after this gang rape, something that the police also talked about recently, saying that given the high crime rate, perhaps 16 onwards should now be considered an adult. What do you feel about that? Do you agree with that?
Again, there were two very strong views on either side of the aisle, and I think the committee has taken on board suggestions on either side, and finally they have come up with the conclusion that it was not necessary to reduce the age. I respect that conclusion. The fact remains, and I've said that perhaps in a program with you, lawmaking or recommendations about changes in the law have to be a function of cool deliberation and reflection, because laws are not meant to be passed purely or only as a response to a incident, but they must be passed keeping succeeding generations and the demands of civilized society in view. Therefore, the committee that was constituted comprised of people who are known to have great learning of law and knowledge of law and all that goes with it. And therefore, I think if they have come up with certain proposals, these would receive the highest priority and the most deep consideration by the government.
One of the other very important proposals and the changes that they've suggested is on electoral reforms. And one specific point they raise is that if a court takes cognizance of a heinous offence against a legislator, whether it's an MP or an MLA, then that person should be disqualified from contesting right away. Now, there's already a debate on that, because we had some politicians saying yesterday, well, that means you're presuming that that legislator is already guilty. What do you think about that?
You know, the Election Commission has also proposed something to that effect. The Election Commission has said in its preliminary proposal that if charges in certain offences are framed by a court of competent jurisdiction, the person concerned must be debarred. Now, personally speaking, I'm not giving my views here as Law Minister of this country, but as a citizen of this country and as a lawyer, I believe that there should at least be one conviction by one court when you are found to be guilty upon evidence before a penal consequence of being debarred is visited upon you. However, if
so you think it's unfair to disqualify a legislator based on a court taking cognizance of charges? Only based on that?
You know, that two very strong views on it. People say that conviction takes forever and ever, and therefore once the court has framed a charge, that should be a good enough evidence of a prima facie case against a person. You can argue in that way as well. But the contrarian view is also a very, very strong view. The law presumes a person to be innocent until proved to be guilty. The terminology in law is one must be found to be guilty.
Is that what you believe
upon
as well?
Evidence. My personal view is that at least one court should have found you to be guilty before such a grave consequence is allowed to be visited upon you. Earlier, what used to happen was, the principle of law is that an appeal is a continuation of a suit. So there was an extreme view that until you are finally convicted, you can't be dispatched. So that we gave a go by long ago. And the law now is that if you are convicted, even by the first court, you are then disqualified. But now the proposal is that you don't have to wait even for the first conviction.
India's #1 news app just got even better. Download NDTV's new app. Fully optimized for retina display. Full screen view. Faster response time. And Sudoku. NDTV's new iPad app. Download now.